Hi, this is Scarlett Sanders, and today I'm going to talk about some lesser known rights of indie musicians. In the digital era, there is some tension between moral rights and rights of remuneration. The creative process of mashups, wherein an artist puts together several existing recordings and manipulates and blends them with perhaps some new parts, is becoming an art form in itself. Sometimes these mashups and remixes are created live, either for a performance in front of an audience or for a live broadcast. In such circumstances, it is therefore impossible to obtain the appropriate permissions in advance. Some authors and performers are quite relaxed about this, whereas the others feel very strongly that their moral rights are being violated. As new remuneration structures develop, this tension is bound to become more of an issue. In the end, it will be a decision for the author or performer as to whether they want control over their works and recordings or whether they would rather relinquish their moral rights, at least the right of integrity. One approach with this problem is to establish a system where the switches are always on unless an author or performer dislikes something, in which case they have the right to turn the switch off. That is, third parties can incorporate the works and recordings of their authors and performers into a mashup. But if one of the original authors or performers takes exception to such use, they have the right to issue a takedown notice. This is how services such as YouTube function. Any audiovisual content can be uploaded to YouTube. But if YouTube is notified that that content is illegal, they will take it down and prevent any further uploads of that particular content. This takedown procedure is defined in the US Digital Millennium Copyright Act, which provides a safe harbor for digital intermediaries and ISPs provided that they operate a takedown procedure if they are notified of illegality. The term copyright or related right protection is governed by what is known as national treatment. This means that although the country of nationality of the author or performer may have reciprocal agreements with other countries via international treaties, the term of protection in a foreign country is usually limited to the term of protection in that foreign country. A more accurate definition would be that member states are obliged to grant exactly the same protection, the same rights with the same exceptions and under the same conditions to the nationals of the other member states who are party to a treaty as they do to their own nationals. I'm going to talk more about this subject in my next post.